Okay, we are live. I'll go to my clerk and look for roll call, please. Jennifer?
Thank you, Your Worship. Welcome to the January 26th Council meeting. I'm Jennifer Connor, Clerk of Ramara Township. I'll begin with roll call of Council. Mayor Clark,
Present.
Deputy Mayor Bell,
Present.
Councillor Snutch. Councillor Fisher is absent. Councillor Tuyu,
Present.
Councillor Goff,
Present.
Councillor Bell.
Present.
Thank you, Your Worship.
This meeting is being streamed live on the Township of Ramara YouTube channel. Be advised that by attending a public meeting of the Council of the Township of Ramara, you are consenting to your image, voice, and comments being recorded and will form a part of the public record. The chair, CAO, and/or clerk have the discretion and authority to terminate or interrupt the live streaming in exceptional circumstances where the content of debate is considered inappropriate to be published. Thank you.
Okay, apology pursuant to section 4.3G and 4.4I of the procedure bylaw 2025-23. Clerk, could you read the motion, please, first? We'll get it on the floor.
That council consents to the return of Councillor Bell to her seat at the January 26, 2026 council meeting following her public apology for disorderly conduct at the November 24th, 2025 council meeting in accordance with section 4.3G, 4.4I of the Township Procedure Bylaw 2025-23.
Moved by Councillor Goff, second by the Deputy Mayor. Go ahead, Councillor Bell.
Thank you. Good morning. As requested, I make the following statement. At every meeting of this council, my conduct has been above reproach and fully within my duties as an elected official under the Municipal Act 2001. The Act requires me to be accountable, transparent, informed, and to uphold my fiduciary duty to Ramara's families and the healthy future of the municipality. My scrutiny consists of spoken words from my seat, no movement and no impolite gestures. With dignity and integrity, I ask legitimate, fact-based questions in good faith in pursuit of healthy democracy on behalf of Ramara's families whose questions today remain unanswered. I regret any misunderstanding or offense that may have been perceived from my diligence. I remain fully committed to Ramara's families, whom I serve humbly and with joy, no matter the cost. Thank you.
I'm
Your
sorry,
worship.
no discussion. I didn't have my microphone on. So all in favor of the apology?
Your Worship,
Okay.
mover and seconder.
I had a mover, Councillor
Okay.
Goff and the Deputy Mayor. All opposed? All opposed, that is defeated. Thank you. Colton, if you could remove the councillor, please. Okay, with that, I will look for the approval of the agenda dated January 26th, 2026. Madam Clerk, whenever you're ready.
That the agenda dated January 26, 2026 be adopted as presented.
Moved by Councillor Goff, second by Councillor Tuyu. Questions arising from the agenda? Not seeing any, so all in favor? Oh, you found it there, Dave. All in favor? Yep, that is carried. Thank you. Disclosure of pecuniary interest by any member of council. Councillor Bell.
It's the NRK.
Deputy Mayor, sorry.
It's okay. NRK. I can't speak.
Okay, any other disclosures? I'm not seeing any NRK file that he's disclosing because he works in. Go ahead, you don't need to say it.
No problem. It's because we do a lot of work with them. We bid tenders utilizing their services, so I can't bid on that, or I can't speak on that.
Okay, thank you. Announcements. Well, very cold morning out there. I hope everybody's keeping their home fires burning. But it was sure heated up a few weeks ago when we had a great announcement here that the majority of council were at, that we were successful on our $30 million application for the sewer and water health and safety fund. So that will do 4 projects in multiple sewage and water systems. So that was great news. Minister was here. We sat down and then we went to see him again at Rome and thanked him again. And of course, asked if there's any other grants that we could apply for while the ball is rolling. So I want to thank the Ford government, Minister McCarthy, who had stepped into that portfolio, and everybody who helped us on that application, because it was well-deserved and it was our time. Any other announcements? Okay, Deputy Mayor, Counselor to you, then Counselor Goff.
Thank you. As always, it was an incredible experience to participate at the Roma Conference, and I was thrilled to attend delegations with the Ministry of Environment and the Ministry of Natural Resources on behalf of the township. I learned so much at all the sessions I attended, especially at our Zone 4 meeting, consisting of Simcoe and Dufferin counties and Halton, Peel, and York regions. It's interesting how much we have in common. And as one of the top 10 aggregate producing municipalities of Ontario, or TAPMO, I was so pleased to learn at the TAPMO board meeting that we are aligned with other aggregate-rich municipalities in our desire for fair aggregate levy reform and quarry accountability. Thanks.
Okay, thank you, Counselor. Counselor Goff. That's because years of plowing in the tractor. I always look to the right. before I
Okay,
look to the
whatever your
left. Go
excuse
ahead.
is, Mr. Mayor. Again, I attended Roma and the minister's announcement, which was great news for us. I also attended the Brecon Legion mini golf tournament. They had some world-class chili there that was made with homegrown Ramara ground beef, which everybody was really impressed with. I believe they raised around $4,500, which is a great thing for their building renovation fund. Also like to thank our staff for working so hard with the Legion Group in order to have them have their occupancy for this mini golf tournament, McIsaac mini golf tournament. So good work, staff, good work, Legion, and good work all our residents that attended the mini golf tournament.
Unfortunately, I was sick. I did want to get there this year. Deputy Mayor.
Sure. Yep. No, I was at the pub putt too. I was on the leaderboard going into the second, but I think there's some cheaters in that game. So I did end up losing, but that's okay. No, I did attend Roma. Went to 5 delegations in total. On the side, there is a trade show. We were able to talk to a few different people. CN Rail was one. We talked about improving communication for our residents as far as this blockage at the railways. The second one was Enbridge. They gave us an outline of phase 3 and gave us kind of a road book to how to apply to get natural gas into Brecon. So we're going to be working with the staff will be working with them to do that. And the third was the Northland. So we have a roadmap as well, hopefully to apply for the next phase of train stops and look at a train stop for Brecon. So that was exciting. So I think that's it. And other than that, I just wanted to again thank the province and the staff for all the hard work they did on that grant. It's a big piece, first substantial grant for Ramara Township in the history of Ramara. So it's fantastic.
Thank you. Not seeing any. So now I will go to public and special meetings account presentations. We have none, and public and special meetings of council. We have none, but we do have a deputation. Georgie Jennings, come on up, Georgie. It's been a while. Just push the button on the microphone. There you are. Perfect.
Got it.
And then speak into it so our folks that aren't here can pick you up as well. Thank you.
Good morning, Mayor Clark and members of the council. I want to speak about who is responsible for paying the $144,744.04, the amount the court awarded to reimburse the applicant's legal fees following the judge's decision to quash bylaw 2020-16, the shore wall bylaw. The court addressed its decision of costs to the respondents, recognizing the parts played by both the Township of Ramara and the Lagoon City Parks and Waterways Commission in the procedural misconduct and bad faith. While it is true that the Parks and Waterways Commission and the then Ward 5 Councillor Commissioner Cal Johnson sponsored and advocated for the passage of this bylaw, it was in fact passed by 3 members of a 7-member Ramara Council, a manufactured quorum. The 3 members who voted to pass this bylaw in 2020 were Cal Johnson, the Ward 5 Councillor and current chair of the Parks and Waterways Commission, Joe Goff, the Ward 2 Councillor, and Mayor Basil Clark. Veteran members of council might remember that for those who joined council last year, here's an explanation of what happened to the other 4 members of council. Ward 1, David Snutch, had previously indicated that he had a personal commitment and would not be attending the meeting. Ward 3, Ted Lamb, called in sick. Gary Hetherington, who represented Ward 4, attended and then declared a pecuniary interest. Deputy Mayor John O'Donnell, who was terminally ill, was placed on medical leave in order to manufacture the quorum. That left 3 members of a 7-member council who voted to pass bylaw 2020-16 on February the 9th, 2020. There was one councillor who requested delaying the vote, suggesting that council take additional time to determine the additional costs incurred with the bylaw. The 3 members of council who were members of the manufactured quorum did not heed that email. They voted to pass the bylaw without questions or concerns for costs that would affect Lagoon City levy payers. The October account voucher presented at the Commission's December 11th meeting indicated that the total amount awarded by the judge in her decision of costs, the amount of $144,744.04, was being charged to the Lagoon City levy payers. In Judge Healy's decision of costs, she stated that the respondents, the Township of Ramara, and the Lagoon City Parks and Waterways Commission were jointly and severally responsible for the costs. The fact that the LC levy payers were charged the whole amount is an injustice. The MARA Act was created the structure of the Parks and Waterways Commission with 2 members of council and 3 Lagoon City residents. The goal was to protect the financial interests of the Lagoon City residents. Now, I am voicing a concern on behalf of the applicant Lagoon City levy payers, the members of the Phase 1 group who protested the passage of this bylaw, as well as the 800+ Lagoon City levy payers who are now being held responsible for the total amount assessed in the decision of costs. At an annual levy cost of approximately $900 per household, this invoice for $144,744.04 represents the total Lagoon City levy paid by 160 Lagoon City families. The fact that this council and township council has the authority to pass bylaws is not in question. However, this council did not have to pass the bylaw. Council did not have to manufacture a quorum in order to pass this bylaw. Council did not have to rush its passing. There was no urgency. There was significant concern and outrage expressed by residents. Yet, 3 out of 7 votes passed this bylaw. The majority of council were either absent or opposed. This quashed bylaw had serious engineering flaws and significant financial consequences that 3 township council members chose to ignore. Today, with a focus on transparency, council needs to accept responsibility for its share of the $144,744.04. When we look back at the 3 who voted for this bylaw, only Councillor Commissioner Cal Johnson represented Lagoon City levy payers. The other 2 votes were cast by our mayor, Basil Clark, and Joe Goff, who was Ward 2 councillor at the time. 2 non-Lagoon City levy paying members of council were responsible for 2/3 of the vote that led to passing the quash bylaw. In fairness, council should be responsible for 2/3 of the decision cost for a total of $96,496.03. Councillor Goff, you were one of the voting members of the February 2020 manufactured quorum. Were you caught up in the "we generally all vote together" momentum?
Listen, we're not going to make personal comments on, please carry on.
You were served as a commissioner. Reflect now. As a commissioner, would you go along with the levy paying or the Lagoon City levy payers being charged the total amount? It is important that council is informed and understands that the $144,744.04 is not the only financial consequence of passing a bylaw illegally and in bad faith. There are significant ongoing legal costs for the applicants and the respondents. The applicant's shore wall construction costs have probably more than doubled while this was being decided. In 2018, the estimated shore wall replacement cost, according to the township's engineers, was $3,150 per meter. It is more than likely that there will be other financial consequences for the applicants and for the township. Who pays matters. The optics are important. Mayor Clark, I want to thank you for referring this issue back to council following my comments at the December 11th LCPWC meeting. Deputy Mayor and Commissioner Bell, this is a today problem for this council. This was the legacy that you received from a previous council. It is yours to manage. The court's December 2024 release of Judge Healy's decision and the March 2025 cost decision have been received by this council. In closed meetings, this council has voted its response. The $144,744.04 has been paid. The township's accounts should indicate council's acknowledgement of its role in the procedural misconduct and bad faith. It is 2026. This is an election year. Councillors, as you consider your political futures and look forward to re-election or possibly a run for mayor, deputy mayor, or the Lagoon City councillor position, know that Lagoon City and the levy payers represent a significant block of votes. Elections are either won or lost on how you manage public perception. Who pays matters. The optics are really important. Thank you for your time. Thank you for your consideration of this matter.
Thank you. I do have to clarify a few things. So, yeah, former Deputy Mayor O'Donnell wasn't on sick leave. In fact, I don't think we ever put him on sick leave. He was an acting councillor right up to the point where he unfortunately passed away. John was still reading emails, still answering phone calls, and trying to do the duty the best that he could in his waning time. And I had many discussions with him. And no, I don't believe we ever put him on sick leave. He finished out his term and unfortunately passed away during that term. There's no such thing as a manufactured quorum. That we follow the procedure bylaw. We also follow the municipal act. You can't manufacture a quorum. You either have a quorum or you don't. And take today, for example, we could lose Dave here. The internet could go down and we'd be down to 4 councillors at this table. That's a quorum. The meeting carries on. Councillor Bell has declared a conflict on one item. He doesn't leave the meeting. He leaves the room for that discussion. He can't say, okay, I'm done for the day. I'm going home, because then we lose our quorum. He leaves the room. We have the discussion, but he has to be back in his chair so that we can pass a confirmatory bylaw at the end of the meeting. Because if you don't pass a confirmatory bylaw, then anything that happened in that meeting didn't take place. So the councillors that declare a conflict, they may leave the room. They don't leave the meeting. So they're still there. You still have a quorum, because that can happen a lot in these small towns. You could have 3 or 4 councillors that have a conflict. quite often there'd be a lot of members of the Legion or something like that, and that is a conflict, and if 4 councillors are members of the Legion and they have to leave, that means the other 3 have to make the decision. That's just the way it is. As long as they remain in the meeting, in the building, and they're back for the confirmatory bylaws. So that was passed using the municipal act, and we did look into that, and it is legally correct. The meeting goes on even with somebody. You never lose forum when a councillor has to declare a conflict. However, they do have to return to the meeting afterwards, or you don't have quorum. So you mentioned something about a vote on, there's been no vote made on the 144,000, and I'm not sure the exact amount. I know it's in your delegation. There was no decision of council made on that. It automatically goes to that budget. Now, later in the agenda today, the Lagoon City have made a request, the Parks and Waterways, that we would provide them with a grant to offset that account. That would be how it would happen. But there has been no vote of council made on where that money goes. It just automatically goes to the department that's involved. So it would be up to council now, later in the agenda, if they wish to make a grant to the folks on Lagoon City and Parks and Waterways to offset the cost.
Thank you very much for that clarification.
Okay, any questions?
So is the quorum because there was 4 people in the room, but 1 with a pecuniary
4 people in the
interest?
meeting, 4 people in the
at the
meeting.
meeting, but the pecuniary interest required no vote. So
Right.
it's still a 3-member vote.
It's still a 3-member vote.
Okay.
Yes, but there's still a
Thank you for
quorum of
that
council.
clarification.
Yeah.
I appreciate that.
Thank you again.
Is there any other questions for the deputation? I'm not seeing any, so we'll have a motion later in the meeting. Thank you, Georgie. I think the mic's off, so then we will go on to open public forum. And I actually have 2 today. So I have Trevor Bruce. I think you're coming up to speak on item 11.5.1, and just push the bar at the front there, the little sketch of somebody speaking, and that'll bring your microphone on. Perfect. Whenever you're ready, sir.
Thank you. Hello, Mayor Clark and distinguished members of council. My name's Trevor Bruce, and I'm a resident of Sunset Drive in Ward 5, Ramara Township. I'd like to speak and provide some more context in relation to item 11.5.1 of today's council minutes regarding Sunset Drive, where my wife and I have chosen to call home. My wife and I purchased our home in the summer of 2022 on what we were informed of by our real estate agent and lawyer was a road assumed by the Township of Ramara. In the 3+ years we have lived here, our road has received regular winter maintenance, garbage pickups, placement of gravel, as well as the presence of a Canada Post community mailbox for the residents of the surrounding community. All of which are indicative of Ramara's due diligence on an assumed road, which is nearly physically identical to the neighboring Georgina Drive, Warren Road, and Holiday Road, where residents pay identical taxes to the residents of Sunset Drive and receive such services. While we agree with staff's recommendation that winter maintenance should continue on our road, there is simply no supporting evidence that our road is unassumed, and we cannot and do not accept this characterization of our road. I implore council to not only accept staff's recommendation to continue winter maintenance, but also clarify that this service is not a courtesy, but is a service provided by the township to its taxpayers whose residence lies on a road assumed by the Township of Ramara. Thank you so much for your time, and I hope we can receive more clarity on this relatively small item that is of critical importance to us as taxpayers of this township. Thank you.
Thank you. Thank you very much. There's no comments on that. We will be deliberating that later in our agenda. Next, I had Michael O'Brien on item 16.6.1. Whenever you're ready, Michael.
Thank you, Mayor Clark and Council. I know that you're going to be talking about the video retention policy later today. And I've noted, I went in and looked at the videos, and we actually have about 2 years of videos out there right now. So I would just like to ask that while this staff investigation is going on, that we leave the existing videos up there, that we don't revert to the 1-year policy until we can make a decision. And if we can find some older videos and you decide to keep or present older videos, it gives you a better starting point. Thank you.
Thank you. So with that, I will move on to our minutes from the previous meeting. And just to clarify, minutes make no decision. When you're approving the minutes, all you're doing is approving what actually took place at the meeting and that it's recorded properly.
That the minutes of the following meetings be adopted as presented. Council meeting minutes dated January 12th, 2026. Council meeting closed session minutes dated January 12th, 2026. public meeting minutes dated January 12th, 2026 regarding stop-up closure and sale of a portion of the unopened Laidlaw Avenue road allowance adjacent to 8168 Laidlaw Avenue, Lot 8, Plan 224, described as Part 1 on Plan 51R 17755.
Okay, thank you. Can I have a mover for the minutes? Moved by the deputy mayor, second by Councillor Snutch. Any questions arising from the minutes? Not seeing any. All in favor? That is carried. Thank you. Now I'll look for a motion to recess into the committee of the whole.
The council recess and convene into committee of the whole at 9:57 a.m.
Moved by Deputy Councillor Goff, second by Councillor Toohey. All in favor? That is carried. That's what happens when I look that way first. Oh, I get the name wrong. So now I'll need a motion that we go into closed session and then we will leave the public. Of course, you're welcome to stay. We'll go to a different room.
That in accordance with Section 239(4) of the Municipal Act 2001, SO 2001, C25, notice is hereby given that Committee of the Whole intends to hold a closed session meeting in the Richard P. Bates Boardroom to deal with matters pursuant to Section 2392E, litigation or potential litigation, including matters before tribunals affecting the municipality or local board. And F, advice that is subject to solicitor-client privilege, including communications necessary for that purpose.
Okay, can I have a mover and a seconder to go in camera? Moved by Councillor Goff, second by the deputy mayor. All in favor? That is carried. Okay, we'll see you shortly, Dave, when we get the technology moved. I think I've got everybody back. Are we live, Colton? We're live. I've got everybody back. If I can get my clerk just to confirm that I do still have a quorum.
Thank you, Your Worship. I can confirm we have quorum.
Okay, so I would look for the motion that we rise.
The council, the committee of the whole rise from closed session at 10:55 and reconvene in open session and report.
Moved by Counselor Goff, second by Counselor Tuyu. All in favor? That is carried. And you have some motions for us, Madam Clerk?
I do, Your Worship. That report CDO 126 be received as information and that report CDO 126 be referred to the January 26, 2026 council agenda for same-day ratification.
Moved by Counselor Goff, second by the Deputy Mayor. All in favor? That is carried. So that takes care of our closed, does it not? So motions arising, which we've done. Council reports, we have none. Board and committee reports, none.
Oh, Your
Council-
Worship, we have one more item.
Oh,
in
you have one
closed
more
session.
for in
Yeah.
camera? Yes, thank you. Go ahead.
That report CDO 226 be received as information and that report CDO 226 be referred to the January 2026 council agenda for same-day ratification.
Okay, moved again by Counselor Goff, second by the Deputy Mayor. All in favor? That is carried. Is that the last one? I forgot there was two. Yes. Board and committee council. So we are on to department reports now. So winter maintenance on Sunset Drive.
That report ID 0426 dated January 19, 2026, titled Winter Maintenance on Sunset Drive be received, and that winter maintenance assistance continue without prejudice and precedence for the 2025-2026 winter season on Sunset Drive, and that the winter maintenance assistance does not and will not meet OREG 239-02 minimum maintenance standards or the township's winter control policy. And that staff provide notice to the impacted property owners that courtesy winter maintenance will continue when accumulations are greater than 100 millimeters, 4 inches for the remainder of the 2025-2026 winter season, and that this report be referred to the January 26, 2026 council agenda for same-day ratification.
So this will be approved as of today. Moved by the Deputy Mayor, second by Counselor Snutch. Just to clarify, same level of service until we can look into the matter further. So we are not going to leave you folks stranded. So with that, all in favor of the motion? That is carried. Thank you. Closure of southerly portion of Mara Eldon Boundary Road, and this is our favorite bridge over on Talbot.
The council be directed to commence the process to stop up and close the southerly portion of the Mara Eldon Boundary Road.
And this is just a little portion of the road that leads to the bridge. It's not the entire area. So on that, can I have a mover and a seconder? Moved by the Deputy Mayor, second by Counselor Tuyu. Any other questions on, I mean, I share the disappointment of the municipality. This was started out as a federal project to replace a bridge that I don't have any answers. They've spent more money now on what the cost originally was budgeted for replacing the bridge simply to remove the old one and close it. So I just disappointment is all that I can say on that one. So all in favor? That is carried. Thank you. Okay, proposed amendment to the environmental compliance approval on our NRK holdings. Do you want to read the motion or do you want to have a discussion? I'll work committee in the whole. What do
I
you
think a
think?
discussion first, Your Worship.
I think we need to start there. So this is one that, of course, we're going to put, well, everybody's read the report and see the concerns that we have. Any other concerns of council members as we send this forward? Councillor Snutch, if you want to start us off.
Thank you. I don't know if it's necessary for me to go through them, but I have provided a list to the CAO on things that we do, which are basically the same. It's mainly around trucker protocols and a couple other things that are already implemented with Fowlers, and I'll be suggesting later with LCP. But Gail, do we have to read these now, or can you just accept that and add them into the letter if required?
Through your worship, I would suggest that the councillor identify those so that they can be included. Yes.
So if you can let us know what it is, and we may add it to the file.
Okay, could I ask, can the CAO, I'm having a hard time locating that document where I'm set up. Is there any way the CAO could go through the highlights, or how do we do this?
Gail, is it something that Dave, that you sent in, or
Yes, I sent it in to Gail.
I hear your pain when you're on one computer. Can't open other windows without losing myself.
Through you, your worship, if I can just ask for your indulgence while I locate that document, because Councillor Snutch and I had the discussion with respect to a few things on the agenda. So just a moment, please.
Perfect. And in the meantime, I will say, I mean, we've pointed out the obvious that the OLT or OMB, I think it was at that time, was, hydrocarbons only. And that was a decision and a ruling there. And I know the other one, which I see in here as well, is the hydrological assessment. I remember when they first opened, M&R was willing to issue the permit on their stormwater management pond design. And it was our engineers that questioned that, and they had to increase the size of the stormwater management pond because they hadn't taken into effect surface water runoff from the rest of the quarry. So again, same concerns here. We're going to want to make sure that if they're increasing the amount of soil that they're treating, is the stormwater management pond adequately sized to handle an increase? Because it was sized according to our engineers for what they're doing now. Now, they may have data showing that, it's never been more than half full. Like that's something that they're going to have to prove that the capacity is there. Go ahead, Gail.
Through your worship, if I can, and I'll just slowly identify these, and Councillor Snutch will, I assume, speak to them, but for the purposes of the motion, what Councillor Snutch was looking at was there must be a driver's protocol acceptable by the township in place. The reduction of hours of operation, water monitoring, hours for performing auxiliary operations, warning signage were the 5 items that Councillor Snutch had identified that should be included within the commentary back to the ministry.
I believe the water monitoring's in place, Dave, but I'm not, I don't have our planner here. I believe it is in place, and that's part of the hydrological study they're going to have to do, right?
Through you, your worship, yes, that's correct. Because the existing, so they do water monitoring currently on the existing ECA and the site plan control. What we'll request is that there be additional monitoring based on the new report that is highly recommended that the MECP have them complete before the ECA is considered.
And we've already red flagged that one. It's in there.
Correct.
I saw that. So, but the driver protocol, Dave, you want to talk on that one briefly?
Unfortunately, I think Gail's got I don't know, Gail, can you just rhyme off the things that were on that list?
Or you're thinking that's for the other quarry?
Oh, no, I suggest that it applies for both quarries that we're discussing and all quarries in the future as well.
Through you, your worship, just in terms of clarity, certainly Councillor Snutch and I were having conversations with respect to the LCP, but also if there were anything further with respect to NRK. So this is where Councillor Snutch needs to confirm that these items were in fact related to NRK. I will identify them again. There must be a driver protocol acceptable by the township in place. He was looking for a reduction of hours of operation, water monitoring, hours for performing auxiliary operations, and warning signage. So if I can, through you, your worship, confirm with Councillor Snutch that those items are related to the NRK matter as well.
Yeah, so I'll get you to speak quick on the driver protocol and the warning signage. What are you looking for on those two, Dave?
Gail, can you maybe just send that document to another monitor I have set up here at davidsnutch@icloud.com, and then I'll take over?
In the meantime, I'll go to other members of council. Councillor Toohey, we will get back to you, Dave.
Thanks. Just before I get into my technical questions, I just have some sort of administrative questions. The deadline for the ERO submission was January 15th. So was this already submitted, or are municipalities allowed extra time, or does this submission get sent directly to the ministry?
General Manager.
Through your worship, yes, the deadline was January 15th. We did make a preliminary submission that said we reserve the right to submit additional comments after this meeting. So that was specifically sent to the ministry. We also had them acknowledge that comment. So we can submit additional after the fact.
Carry on, Counselor.
Thank you. And just, and this, the second bullet in the municipal framework of your letter section, it states, for clarity, the current official plan and zoning bylaw do not permit, and then it lists 3 things. I'm just curious as to which official plan we are working with. Is it still the 2003, or is it the one that we're just basically waiting on for signature from the county?
General Manager.
Through you, it'll be for both of them. It is not a permitted use of this site.
Yeah, they're both the same.
Thanks. Can I start
Yes,
in with my
carry on.
technical questions? Yeah. Okay, so under the environmental protection and technical basis for decision, it states that operational changes, e.g. untested soil intake, broader contaminant mix under QP discretion. Can you please clarify what kind of untested soil could be brought in, what the contaminant mix would be, and who would be the QP, which I guess means qualified person?
General Manager.
Sure, Your Worship. So the request, the proposed amendment is asking for untested soils to be brought to site in the event of an emergency. So those are the soil mix that we're talking about. We don't know what that would look like. They also are asking for an expansion in their ECA to allow for more soils to be treated on site than just the hydrocarbon impacted soils currently tested. And the QP discretion, you're correct, that's the qualified professional or qualified persons under the Environmental Protection Act, specifically for excess soils. So that would have to be retained by the owner of the property managing that site. That's who that would be in regards to.
Carry on, Counselor.
Thank you. I guess regarding that, because untested, we don't even know if it's a soil that's not permitted under our official plan. I propose that one of the additional terms in our letter be, if the untested soil proposed to be received at the facility cannot be guaranteed that it is not hazardous wastes such as motor oil, hydraulic oil, and solvents, which incidentally are not permitted in the US, or other oil field waste components such as elevated concentrations of metals, salt, or wastes containing naturally occurring radioactive materials, or NORM, which are not biodegradable, then this application should not be approved, as our OP and zoning bylaw does not permit the acceptance of soils that are not treatable. Incoming untested soil cannot be claimed as treatable.
Maybe a clarification. I thought soil had to be tested on site before it was even allowed to be moved. So there should be no untested soil landing in here.
Through you, Mr. Mayor, that is correct. So the current ECA that they have has to have the soils tested prior to it coming to site. In this proposal, they are asking for untested soils to be allowed to come in the event of emergency.
Oh, I see. And then they would test it on site.
Correct.
Well, define emergency, I guess, because I always, maybe in an event of emergency, but I've always thought under the new provincial law, soil had to be tested before it can leave a site.
Through you, yes. So the excess soil legislation that applies here, whoever is the owner of that soil needs to understand what it is.
Yes.
And generally speaking, they're going to communicate that information to whoever the receiving site is so that everybody's on the same page. In this case, because it would be emergency based, that's where they're requesting untested soils. So
I can tell you where I feel on that one. Counselor Tu, you will follow up.
Thank you. This is sort of going again towards the unknown content of soils. So I see, do we have our planner Jen Stong here, or somebody who's able to put up our GIS mapping to indicate where the site is in relation to the layer for the highly vulnerable aquifer?
Just waiting for that now.
Okay, well, while we're waiting, this would be what I would propose in another one of our points to be included. Given that all of Ramara sits above a highly vulnerable aquifer, including this site, which sits amid vibrations from quarries, resulting in potential further fracture, there are significant concerns for risk to groundwater contamination, threatening source water protection.
Thank you. And there you can see where it is now on the map.
Yes, thank you. And can you please add the layer for highly vulnerable aquifer?
I have turned it on, but it's not loading.
Okay.
Sometimes it takes a little while.
Any other comments while we're waiting for that to load before I go to Councillor Snatch online? Councillor Goff.
One of the concerns I have is the liquid soil. I know it's soil filled with a higher water content, but then we still have the possibility of it running off and contaminating. I don't understand how that will work.
Liquid soil to me sounds like this is something they want out of a vac truck. Is that what I'm understanding? And then they want to test it on site after it's brought in?
Through you, Mr. Mayor. So liquid soil does imply that it doesn't pass the slump test and there's some very specific requirements under the legislation for that. In this proposal, they are also requesting that they receive those liquid soils, whatever the source may be, because it can come from more than just a Vector truck. So to your point, yes, that is, and we have to remember that this is an ECA proposed amendment. They haven't gotten into the details yet of how they would manage that on site. They're just asking for permission to be considered for it. So again, if your direction is to include more stronger language in the letter about that, we can definitely do that.
I think our position in council is the same as staff, that it's hydrochlorides only. That was the ruling, and we need to hold firm on that. And then so the liquid soils untested would not be allowed. Like everything has to be tested that comes into the site. And I think that's reasonable. There's the overlay of the vulnerable aquifer. I assume that's all that purple. Is that what I'm assuming?
Yes, all the red is considered highly vulnerable aquifer.
Yeah.
That's great. Can I just read out according to the definition from, what was it, Conservation Ontario, the definition of a highly vulnerable aquifer. There are areas of soil or rock under the ground where cracks and spaces allow water to pool. They are considered highly vulnerable based on a number of factors, including how deep is the underground, what sort of soil or rock is covering it, and the characteristics of the soil or rock surrounding it. Soil or rock that has many large cracks and spaces and is looser rather than more compact determines how easy and how quickly it is for water to flow into an aquifer. The faster water is able to flow through the ground to an aquifer, the more vulnerable it is to contamination.
Yes.
Thank you. I have another thing. The last request in the letter I'm hoping to amend. It asks the MECP to require the proponent to submit confirmation that liner systems, berms, storage pads, and emergency response protocols are engineered to safely manage higher risk materials, given the request to process soils with metals, PCBs, under QP discretion, and larger on-site inventories. My opinion is that leaving this sort of oversight with any proponent is problematic, if not an absolute conflict. What proponent would not confirm that their operation is managing high-risk materials safely? In my experience, I can confirm that liners and pads are not necessarily impermeable. There needs to be an outside third-party regulatory body and group of professional engineers involved with this to ensure maximum accountability. If 100% impermeability cannot be reassured in any potential disaster situation, then this should not be approved. And I've got a more sort of, so the comment I have, I can send that to you, Rebecca, but it says basically, if the untested soil proposed to be received at the facility cannot be guaranteed that it is not hazardous wastes such as motor oil, wait a second, hydraulic oil and solvents not permitted in the US, or any other oil-filled waste components. Oh, I've read this one, sorry. A third-party regulatory body and group of professional engineers is required to ensure maximum accountability. If 100% impermeability cannot be guaranteed in any potential disaster situation, then this should not be approved.
think though, on the original design, that's what they had to show. When they put their liner down, there is clear stone under the liner. There is water that is tested that gets through the liner. But again, that ties to the same concern. They're trying to expand. And this was all sized for the size of operation they have now. So they would really have to prove to us that they could even expand their operation under the hydrocarbons. Because again, it was all sized for the current load that they're testing. But is there anything you want to add to that, General Manager? But I think it's covered in there, Councillor Tuyu. Go ahead.
Through you, yes. So this information would always be submitted by the proponent, but we do peer review that information as well. So, and I would remind too that, you know, engineers and qualified persons are very legislated and they have their own code of ethics and professionalism. That's who we're requiring to submit these. And then again, the township consultants would also peer review those alongside the ministry in order to approve the ECA amendment in the first place.
Go ahead, Councillor.
Thank you. Yeah, I have another question that residents have been asking. Where do the contaminants go when the soil is treated? Into the water or into the air? And how are they captured and disposed of?
I believe the hydrocarbons are digested and they're broken down into inert soil, but heavy metals, no, that wouldn't be the case.
Through you, yes, that's a very technical question about the operation. My understanding is that, yes, the hydrocarbons are currently digested. They break down into their different components and it's managed through that process. And then for the potential for these other ones, that would be, again, a technical question for the proponent to answer.
Councillor?
Thank you. Just to follow up, yes, because dust and vapor emissions may pose air quality concerns with regard to land farming, specifically for hydrocarbons. So one of my additional points that I would like to have included in our list is dust and vapor emissions may pose air quality concerns. Proponents should install an appropriate industrial dust filtration system designed to handle those kinds of emissions.
Okay, getting a nod. Now, if there's no other councillors, Dave, I'll go to Councillor Snutch online.
Thank you. I did not get that email, but I found my rough notes, which will be enough for me to go through this. So I went back to the OLT hearing that we had with Fowler's, and a lot of people say we lost that hearing, but there was a lot of things that were agreed upon in that OLT hearing that has made that quarry safer and better for the residents. So I think they should apply to all the quarries. Or the trucking operation. So as far as trucker protocol, the things that were decided by the judge in the OLT hearing was basically related to not stopping at Highway 169, coming to a complete stop. I have witnessed that myself. I think Dana has too, where in order to get moving, they actually speed up on the concession road. They look to their left and they take off on the highway so they don't have to gear down and gear up. So two things related to that. The OLT wanted a camera system in place. We don't have to reinvent it. We just have to do the same thing that was won to us in the OLT case with Fowler's. In addition, I think the speed limit on that road should be reduced to 40 kilometers so they can't ramp up. It's only a very short distance. It's not going to make any change. The next, this was also in the OLT hearing. As you remember, there was over 3,000 hours of video evidence of these truckers. I don't mean that in a negative way, but the people who drive the quarry trucks seem to be more concerned about what they're doing than what the residents want. The next thing was having tarps. We wanted to insist that they tarp their loads, even on an empty truck. Full truck, empty truck, put your tarps on. These stones come out, they hit other cars, they can cause accidents, but that would all go into a document called a driver's protocol. And in the Fowler's case, if truckers don't follow that, they are banned from going back to that quarry operation. So the video evidence also shows they back up on the highways. They should not be allowed to park on either concessions or 169 while they're waiting for the quarry to open in the morning. That's a common occurrence. The dust suppressant system, that's maybe what I meant. I'll come back to that, sorry. I think the township should have, like, they're responsible for cleaning the dirt off the road, but there's no definition of how often they have to do it, when they have to do it, or, you know, well, it's not that bad, we'll do it later. I mean, I think that, I think a standard has to be set for all these operations. I'll go back to the water point I was going to make, and I don't know if you put that under driver's protocol or you add that into, maybe that's what I meant by water. Crescent systems are left up to the operators. And as Dana has witnessed, and maybe other counselors, the Fowler dust suppressant system used to be a household sprinkler placed on the side of the road with water shooting up about maybe 1.5 feet in the air, only on one side of the truck. I think we have to define what, if they're going to have this many trucks going up and down, we need to look at the proper way to have a dust suppressant system, not leave it up to the quarry operator. The next thing is the enforcement, and I've talked to Gail. It's clear by the Auditor General's report that these quarries are not being monitored as per the Ontario standards. And I think there should be discussions had. What happens when they're not being monitored, and where the role of the township come in to take over that responsibility at the expense of the quarry. And all of this, I think, can come back to when we talk into cameras. Camera systems are very inexpensive today. They can be set up at the stop signs up there. They can be set up at the entrance to the quarry. These systems, these closed circuit systems, should be able to be accessed by the township and accessed by the quarry, so they can monitor what is going on in the quarry. Even in our finances, we have on that situation with NRK, I think the original projections were about $300,000 a year in revenue, but we have no idea how many trucks are going in or coming out except for their own reports. And I think these closed circuit cameras would really help us enforce that. I think it's time to end the common response by the quarries, which before we had in the Fowler's OLT, that the quarries would say, they basically say the drivers are independent contractors and they have no control over them. That has to stop. And that's what happens in a driver's protocol.
Okay, I think so. I know.
So
Yeah.
No.
I can see if I can get some answers on some of that.
All right, let's
Yeah, we'll start off. This is a license. Again, this is them applying for a larger license. I don't see why we couldn't ask for a driver's protocol now to be put in place as part of that process. I'm getting the nod from the general manager.
Absolutely. This is where we wanted to hear that feedback, and we can include all of these comments as per council's direction.
Yeah. So that one, and the other one was, I'm not sure about.
I'm getting a little. What did you say, Mr. Mayor?
The driver's protocol. Yes, we're just getting the nod. We can put that in. I'm trying to go through them one at a time, Dave. So yes,
okay,
we can do the driver's protocol and get that added. I think that's something anytime any of the licenses are increased now, we're going to want to see this driver's protocol put in place. The cameras, certainly, I think we could ask for one on the quarry and even on their entrance and exit. I don't know. I think we'd be pushing it too far for them to put it on our property on a license. Like a zoning is somewhat different than a licensing. They're just increasing their tonnage, but I think we could ask for a camera on their entrance. Could we not?
Through you, Mr. Mayor. Yeah, we can absolutely. And honestly, at this point, we can ask for a bunch of different things if we wanted. Whether it's something that comes to fruition will be another conversation.
And same with the stacking of vehicles on our roads. They are not to be parked on our roadways waiting for the quarry to open. So that will be a stand. I think we asked for that on every one, Dave.
And currently concession BC, there is no stopping or waiting. That's already in place right now.
And I believe the county road is the same. I don't think you can sit and idle on the county road either.
There, through you, Mr. Mayor, I don't know that it's signed that way,
Okay.
but I do believe that the county would probably have been in discussions with the quarry owners in that area to make sure that that doesn't happen.
So the other two you had here, Councillor Snutch, was signage and reduction of hours. I mean, the reduction hours is going to be a tough sell because they're increasing. They're up, but we certainly wouldn't want any increase in hours.
Through you, Mr. Mayor, yes, that's correct. This proposal is that they're asking for additional site hours.
Yeah.
And that's where I think we would not be able to pull back what's already in existence, but we can confirm that we do not want an increase in hours.
So if you got that one, Councillor, we're objecting to any increase in hours. And I think the last one was signage. Can you just let us know what you're thinking around signage?
Well, in the Fowler case, there was wording to letting the public know what may be happening in the area. It was a warning to school buses that blasting may be in the area, etc., and quarry trucks. I don't know. I just think it would be a good idea to address it. If we go through it all and it's not necessary, but I think we can have some signage that would be better for our residents, especially people who may not be residents, who also hear this loud bang, sorry, I might be getting the two mixed up here. But I just thought there should be signage identifying what's going on that property with the contamination, etc. I think the public has a right to know.
I'm looking at my
I'm
general
also
manager.
concerned as this.
Let me get an answer to that one, Councillor.
Through you, we could include in the letter some language asking for additional signage to communicate the operations in the area.
Yeah.
We do need to recognize that is a busy area, that this isn't the only operation of that nature in there. Well, it's the only soil remediation, but we do have the quarries that are adjacent to it. So we'll need to be careful that we're not singling this individual company to sign it for all of the companies along that
Right.
area. So.
But something to identify maybe
Council
what's.
also considered this. Yeah, council also considered this when the sewage trucks were dumping in the fields, that those fields have to be identified. So something like that, but I just want to we don't have to come up with the final answers today. We'll just start getting the topics on the issue. The one thing I left out on the driver's protocol is that in the videotapes that were provided in the Fowler's case, these drivers, when they leave or while they're waiting, don't have access to proper washroom facilities. And I think it should be mandatory, and I hope they do. They might already, but I think we should insist that they be provided because of the volume. We got 100 trucks a day going into some of these quarries on peak times. And I think that should be noted. The last thing I had on here, it's not related to the truckers, but it's related to the rehabilitation. This is getting very big, and I want to know what happens down the road when they don't have the ability to fix the property back to a use down the road, and whether we should have some type of deposit or bond at the township, because we know that a lot of these places that have these huge commitments will either apply for a license to change it from a lake to a dump, or they will apply to, or they'll just walk away from the property because it's too expensive to rehabilitate it. And I'm happy with what council decides in general. I'm just saying, I think these would be points that would benefit our residents a lot.
Yeah, this particular one, I believe there's no plan. Because it is considered a waste site, even though it's treating soil. I don't think there is any plan to rehabilitate. It is to be an ongoing use, correct?
Through you, yes, that's correct, because the consumable product is being trucked in. It's not being extracted from the ground, right? So it could operate in perpetuity.
Yeah, because once they are finished building their berms, the soil is treated and then it's exported again. So this is an ongoing. There is no rehabilitation plan for this site. I'm sure the quarry section that is not part of this application would fall under that, or they may make an application expand even larger, but.
Well, maybe it's just worth a discussion.
Yeah.
For staff.
Okay. So I think we got a lot of those facts and I'm not seeing any objections from council members. Counselor to you.
Thanks. Just referring to the traffic safety agreement that we managed to get from Fowler at the OLT. I've got a copy of that if we don't have it here. But one of the things that we sort of did more of a deep dive on in the CLC with Fowler is that there's kind of a 3 strikes and you're out rule with the traffic safety and the cameras. They're very good at spotting the license plates and who doesn't stop at the stop sign, who doesn't have their load covered. And then if that's found to be a problem, that particular truck and driver are not welcome back. So that might be important to ensure is in any kind of traffic safety agreement. The second thing was that we had worked on at the CLC was kind of an individual report of concern type thing where residents who don't necessarily know who to phone when they see something going horribly wrong, they can make a complaint, and that these complaints should be documented and shared with the township so we can see what's going on.
Counselor Goff.
Counselor, to you, I agree with you to a certain point, but what we have to also realize that this is on a haul route and there's more than just NRK. There's 4 or 5 other quarries that use that haul route. So it's going to be hard to distinguish as to what quarry. We're going to have to make this enforceable for every quarry along there.
Well, this is what I like about the motion, though, that every time they increase their licensing now, we're gonna want to ask for a driver protocol. And cameras at the entrances so that this becomes standard. And eventually every quarry will have a camera and a protocol and then clarify some of the hours of operation. So Counselor to you.
Just to clarify what you were asking, the one for Fowler, it's a system where it matches the truck within the quarry to the one at the stop sign, because we had concerns like, what if it just catches a regular local delivery truck coming from the end of switch or something like that? And they said, no, they have to cross-reference that it's coming out of the quarry and that it matches the one at the stop sign. So I think they figured it out, but great question.
Okay, so we're gonna have a bit of a motion to draft here on the comments that are made. Do you need a few minutes, Madam Clerk? or-
Yes, your worship, please.
So why don't we take a break until 11:40? Is that 11:45?
That's fine. Thank you.
Until 11:45, moved by Counselor Goff, second by Counselor Tuyu. 11:45, we'll be back. All in favor? That is carried. We'll give time to draft this up. Okay, I'm gonna call it 11:45, depending on what clock you look at. If you can confirm, are we live, Colton? We are live. I'll look for some quiet in the council chambers, and Madam Clerk, if you can confirm that I still have a quorum.
Thank you, Your Worship. Yes, we do have quorum.
Thank you. So I think we have a motion drafted.
We have a motion, and what we'll do, Your Worship, is we'll put it up on screen. I'll read it, and then council can discuss if there's any amendments to this motion or changes of the wording.
Thank you.
The council received staff report ID 03-2026 dated January 14th, 2026 regarding the proposed amendment to the environmental compliance approval number 6332 A2 GNRY, and that the township comments to the Ministry of the Environment, Conservation and Parks state that the proposed amendments to ECA number 6332 A2 GNRY include activities not permitted under the township's current official plan, zoning bylaw, or site plan approvals, and that the application is premature pending the required municipal planning applications, and that the following additional comments from council be incorporated. Creating a township-approved driver protocol, reducing hours of operation, establishing water monitoring procedures, defining hours for auxiliary operations, implementing monitoring camera systems, requiring securities for long-term site management, implementing township rules regarding the cleaning of roads, enforcing Ontario standards with township monitoring at the expense of the quarry, installing adequate warning signage, consideration for a highly vulnerable aquifer, independent oversight by a third-party regulator and engineers is required, and that the project should not proceed unless 100% impermeability can be guaranteed. If incoming soil cannot be guaranteed free of hazardous or non-treatable contaminants, the application must be refused. Establishing a clearly defined dust suppression system, which includes installation of an industrial grade filtration system, and that council authorized the mayor to sign and submit council endorsed comments to the Ministry of the Environment, Conservation and Parks.
You'll move that, Councillor Snutch? Seconded by Councillor Goff. I look this way first. Any other questions or comments? I think we got it all there. All in favor? Opposed, if any? That is carried. Thank you. And we'll get our deputy mayor back in the room. Well-written motion. Thank you. That's in our case. So now we're on to carryover of capital projects. So we'll get the motion up on the screen and then we can go from that.
The report ID 06-26 dated January 21, 2026, 2025 carryover capital projects be received, and that council approve the carryover of the 2025 capital projects as listed in Table 1 of Report ID 06-26 for a total amount of $665,000, and that council authorized staff to fund $655,000 through the reserve funds and $10,000 from the Experience Simcoe County 2025 Tourism, Culture, and Sport Enhancement Fund Grant, and that this report ID 06-26 be referred to the January 26, 2026 council agenda for same-day ratification.
Okay, thank you. And I'll apologize. The last motion that we just did is that same day ratification because it doesn't say so in our notes for the NRK, or is that going out after the next council?
Not same day, your worship.
It's not? No, there's time on that one. Okay, perfect. Thank you. So on this motion, it is on the floor. Can I have a mover and a seconder? This is our carryover, moved by the deputy mayor, second by Councillor Tuyu. These are our carryover projects. We require a bylaw to release the money that is, I guess, sitting in reserves. Anything you want to add, General Manager?
Through you, Mr. Mayor, just that this is going to help us, the ice storm recovery obviously really not only took time, but it also took staff resources. So we were hoping to accomplish more than we did, but these ones will hopefully have addressed shortly in the new year here.
Okay, any other questions from council members? Councillor Goff.
Yeah, the dock road, dock repair. Is that also taking into account, making sure that all our municipal, I guess, road allowances are being adhered to and there's nobody encroaching using it?
Through you, Mr. Mayor, we have requested a survey and I do know that the survey is done. We're just waiting on that final report to identify those as we move through that project. So this is just to make sure that we have the funds available for that entire
you.
project.
Okay, so this is just releasing the funds. Go ahead, Councillor Snutch.
Yeah, I see it's releasing the funds. I just wanted to know why McCray Park, we're not just carrying over, it's adding money. And I was just didn't understand.
General Manager.
Through you, sorry, that was, I should have included that in the report. When we went out for tender, so the amount requested is the amount tendered by the contractor for Georgian paving. So we are overall in all of our roads projects significantly under budget. However, those couple of line items are over what we had originally budgeted for.
We're carrying over 333 plus we're adding an additional 150 or whatever.
Correct. That's correct.
Thank you.
Okay, if there's no other questions, all in favor? Opposed, if any, you're in favor? Yep. All right, that is carried. Thank you. So a motion to rise from committee of the whole and reconvene as council.
That the recommendations of Committee of the Whole be referred to the next regular meeting of council to be held on February 9th, 2026, with the exception of the following items, which shall be referred to the consent agenda later today. Item 11.1.1, CDO 126, unassumed township roads. Item 11.1.2, CDO 226, litigation update. Item 11.5.1, IDO 426, winter maintenance on Sunset Drive, and 11.5.4, ID 0626, 2025 carryover capital projects, and that Committee of the Whole rise and council be reconvened at 11:53 a.m.
Okay, moved by Councillor Goff, second by Councillor Tuyu. All in favor? That is carried. So now we are back in council. And we'll deal with the consent report from the previous council meeting. So those are the first ones that are on the agenda, which is item 12.1, and there is two of them here. 12.1, which is the lease agreement, and also 12.12, which is the official plan amendment for, which one's this one here? Oh, I thought that was both. For a
Yes,
separate-
it is, your worship.
Yes, here we go. Yes, these are the two. So the only one we're voting on, now that we're on to 12.2 on our agenda, or do you want a motion to pull it? We have it as a separate motion. I don't have that in my actual minutes.
We'll do a separate motion, your worship, and we'll pull it out. We'll adopt 12.1.1, and then we'll pull out, motion will include pulling out section 12.1.2.
Yes, I assume council wanted the new quarry as a separate motion and a separate vote. So we
Okay.
are, do you need a motion to pull it out?
Yeah.
You'll read it to us. Thank you.
That the recommendation is set out on consent agenda A, reports from the January 12, 2026 Committee of the Whole meeting be adopted as presented, with the exception of item 12.1.2, which we voted on separately. So this reflects voting on the report ID 0226, which is the lease agreement, your worship.
So this is only on the lease agreement for, I just forget the name of the road, Laidlaw Avenue. So moved by Councillor Goff, second by Councillor Tuyu. All in favor? That one is carried. Dave, we're voting on the lease agreement for Laidlaw. Yes, that is carried. Thank you. So now secondly is
I agree.
yes.
Through you, your worship, just for clarification, it wasn't specific to Laidlaw. It was
Oh.
the matter in closed session.
Oh, okay. Yep. Perfect. I know the one you mean. That's okay. So now we are on to the LCP quarry.
That recommendation report BP 0126, official plan and zoning bylaw amendment files OP-423 and Z-1123, 1506 and 1646 Highway 12, and 2440 and 2530 Concession Road 1 LCP Quarry Limited as information, and that staff be directed to provide a report to Committee of the Whole about next steps related to BP 0126.
Okay, so I need to put it on the floor, moved by Counselor, yes,
Through you, your worship, if I can,
Okay.
certainly if you want to get it on the floor, but if I may just explain a particular process if members of council wanted to head in that direction, but if you want to move her in a seconder.
all right. Well, go ahead and explain the process and then I'll get the motion on the floor.
Through your worship, if I can just explain what this motion ultimately, if passed, will result in. If this motion is passed, your worship, it would result in the application being received, which is essentially a non-decision of council. It will then ask for staff to do a report on the implications of a non-decision. So if this motion is passed as is, that is essentially what will occur, a non-decision, and staff will do a report on the implications of a non-decision. I do understand that, your worship, that there may be some other interest in other types of motions. But certainly, as you go through the process, if you get it on the floor, and if there is, before you call the vote, perhaps we could have a discussion in terms of what that will ultimately result in before you call the vote.
Perfect. So what I'll do is I'll get the motion on the floor because it is a motion in our agenda, and then look for amendments or comments on the actual motion. So to get it on the floor, could I have a mover? Counselor Goff, second by, just to get it on the floor, Deputy Mayor. Thank you. The motion is on the floor. Counselor Snutch, did you want to start us off on comments? Thought I saw your hand earlier. Oh, you're muted, Dave.
I was just putting it on the floor, but I can start if you want. I do have to call up another page on my screen though, so give me 1 second.
Sure. Oh, you're automatically muting, Dave. I don't know why. You'll have to unmute yourself again. You should be good now.
Good. Okay, well, so I'd like to introduce an amendment.
All right.
All right. I'd like to use the amendment that council deny the official plan amendment application OP 423 and zoning bylaw amendment application Z-11/23 submitted by LCP Quarry Limited respecting the lands municipally known as 1506 and 1646 Highway 12 and 2440 and 2530 Concession Road 1 as set out in report PB 0126 due to the following reasons. 1, noise impacts. The applicant has not provided sufficient information demonstrating that quarry operations can be conducted without unacceptable impacts on nearby sensitive land issues. 2, blasting impacts. The applicant has not dealt with the unresolved concerns related to vibration safety and potential adverse effects on surrounding properties and the community, including the following items. Blasting done by a licensed blaster using the TAROC model. No blasting or hauling on Saturdays. No crushing or processing before 7 a.m. and operations limited to 7 a.m. to 7 p.m. maximum. 3, air quality impacts. The applicant has not provided sufficient assessment and plan for the mitigation of dust, particulate matter, and emissions associated with quarry operations and related traffic. Traffic impacts. 4, traffic impacts. The applicant has not provided analysis and mitigation strategy for increased heavy truck traffic, road safety, and impacts on the local and regional road network, including but not limited to driver protocols, mandatory tarping of trucks, compliance with stop signs, no roadside waiting on concession 2, adequate on-site washrooms, township approved dust suppression systems and regular road cleaning, installation of cameras at key locations with township access at the applicant's cost. The applicant would have no concerns if the township reduced, to get acknowledgement from the applicant that the township, that they would not object to any reduced speed. And if the township reduces it to 40 kilometers an hour from the quarry to Highway 12, which is only about 450 meters, but it'd slow down the trucks before they get to the highway. Next, all traffic studies must account for all existing and proposed quarry operations. In other words, if NRK is going to add 100 trucks, and I think we've got another 3 applications on the board for quarries, we have to look at a road study that calls 500 trucks, not just 100 trucks. And this quarry alone is 57 out at maximum pack and 37 in. Point 5, enforcement. Consideration has not been given to granting the township the right to access and inspect at the applicant's expense Point 6, the applicant shall agree not to restrict or comment on future development applications. And this means that in an area where somebody already has the right to build a house and they want to build their house later on, the quarry can't object because it's too close. Just like happened across from Fowler's on Switch Road earlier. So that's my amendment.
So I think that would be a new motion. Then what we'd have to do is defeat the motion on the floor, and then you can enter that as a new motion. We're just getting clarification from my clerks on that. And so that wouldn't be an amendment, but it could be a new motion if the motion on the floor is defeated. So and the motion on the floor, of course, is a non-decision, which I don't think any of council appreciates at this point. Some of the options I think we can go forward is, I think we're looking for a staff report, and some of those concerns could certainly be brought up in the staff report. My suggestion would be we defer the decision on the quarry until such time as we get our staff report back and include those items in the staff report, including some of those requests that you made. I think we can put those requests through to the quarry directly. You know, things like cameras, things like, well, the speed limit, I don't know. There's some of them we could certainly put those requests straight forward to the quarry and see. They may comply with some or all of them voluntarily. But I think first we would have to deal with the motion on the floor. CAO Jackson, clarification.
Through you, your worship, certainly just what you've identified, if that is your preferred choice, then what you could do, your worship, is divide the question, which is, I think you might be familiar with splitting the question. You would postpone the segment of the motion that receives the application as information. You would postpone that. Then you would look to introduce the motion for a staff report, but amend that to include the items that have been identified as items to be considered. And furthermore, not only the staff report, but direct staff to have a conversation as well with the proponent prior to reporting back to council. So if that is your preferred direction, that is the approach that you would consider.
So on the motion, that would be an amendment to the motion on the floor. So
I will move that.
Councillor Goff will move that. Do I have a seconder? Deputy Mayor will second the amendment, which is deferring decision on receiving it for now until such time as we get our staff report back. And then as part of that amendment, the issues you just pointed out will be part of that staff report, including a request to the quarry to see if they will agree to some of these prior to us making a final decision on the quarry.
So your
I'm
worship,
looking back at CO Jackson again.
if I can, your worship, if you've got a mover and a seconder, if I can ask the clerk to put on the floor so that everyone understands sort of where they're heading. The first component will be to put the motion to receive the applications as information on the floor.
Yes.
You would look to postpone that pending the outcome of the staff report.
Right. So you
Okay.
want two separate, we'll vote on that one first. So we'll defer on the decision until we get the staff report. And then the next one will be the staff report and what we'd like to see in it and requests made directly to the quarry. So I'll wait for the motion to come up and then everybody can have a look at it. Now, if any councillor's idea is to still decline the quarry, then you would vote against this and then just wait for the opportunity to, because this is an amendment to the original motion. Or vote for the amendment and vote against the original motion as amended. Go ahead, Councillor Snatch, just trying to clarify the process.
Yeah, so, yeah, thank you very much, because I'm a little confused, but what I'm trying to do is just deny the application.
Right.
So I guess I'm voting no to the first two and then yes to the denial that's coming up.
You may
that I put
want
on
to
the floor.
vote, no, you may want to vote yes for the amendments because that's irrelevant, but then no to the motion as amended. So when we finish the amendments, the main motion as amended,
Yeah, I see no point.
and then when that's defeated,
getting-
or you can vote against all three. Yeah.
Since this happened a couple weeks ago, I've had extensive talks with various people, and I don't think I need a report that tells me what the difference between a no decision is and a full denial.
Right.
I understand what happens at the OLT if we go in with a non-decision, and I understand what happens if we go in with a denial. And I think denial gives us the best shot. It still allows us room to have some discussions, because I'm sure they'll phone us right away and say, well, why did you turn it down? And then we can get into some discussions on why we turned it down.
Right. But the denial was not coherent with the motion that was on the floor. An amendment is, so that would have to be a separate motion to deny. So that's why we have to go through the amendments to the motion first and then vote on the main motion. And if that's defeated, then the new motion to deny could be put on the floor.
Okay, so just Mr. Mayor, so for me then, I'm denying, and then approving if I want them. Thank you very much for clarification.
I will make sure, we know exactly. Councillor Goff.
But with the deferral, it actually gives staff and to have that conversation to maybe include a lot of the points that for your reasons for denying it, Councillor Snatch.
But my understanding is the staff report was just going to come back and tell us the different circumstances with a non-decision does and with a denial does.
We're actually the next motion will be to amend the staff report. So that's why. So the first motion is to split them up. So I'll get that motion on the floor first.
That recommendation report BPO 126 official plan and zoning bylaw amendment files OP-4/23 and Z-11 23, 1506 and 1646 Highway 12 and 2440 and 2530 Concession Road 1 LCP Quarry be received as information.
I don't think that's it. We wanted to split the two up, did we not?
And wasn't that supposed to be postponed?
And deferred.
So through you, your worship, the motion that I believe the clerk just put on the floor was that the application actually just be received,
Oh, okay.
right? And so what you would be looking to do, based on what I've heard from you, is that you would be looking to postpone/defer. We'll use
Defer.
those, as a sort of same meaning. You'd be looking to defer that particular decision.
Right.
And so until you've had the benefit of a staff report.
Right. So then we would need that added to the motion.
Yes. And so the issue, your worship, then becomes, just so we're very clear, if the next motion to ask for a staff report, which includes all of the parameters that Councillor Snatch has suggested, and furthermore asks staff to speak directly with the proponent. If that motion fails, then you have ultimately postponed your non-decision until a staff report comes
Right.
forward. If there's no staff report, then that would be put on a next agenda for you to
Right.
ultimately deal with.
Deal with it the next agenda. All right.
Okay? Is that
Okay.
clear, your worship?
Yes.
Yeah.
So, but we need the word defer. So I need a motion to defer that motion.
Through your worship, that can be a verbal motion. So
All
if you
right.
have a mover and a seconder for that motion to postpone.
Okay, moved by Counselor Goff, second by the deputy mayor to postpone the receiving of the motion until such time as we get the staff report. So that's the motion that's on the floor right now, Dave. So we would not be, we're deferring the decision on the quarry until the staff report. That's the motion on the floor at the moment. So I would look for all in favor, and I will put my hand up to make it easier. 3, all opposed. 2. So that motion is carried. So now the motion on the staff report.
Through your worship, what we will do is put that on the screen, that staff prepare the report. So clerk staff will put that on the screen. And if I can ask members of council to take the time to review all of that. And is there anything further that should be included?
Oops. Yeah, we're waiting to get the motion on the screen. Go ahead.
I'm confused. So you're basically saying now that we're not making a decision to deny that today? We can't do that?
Right now, again, if this motion for the staff report is defeated, then the same motion will be coming back with the staff report on what happens if there's a non-decision, which was the original decision of council. But if that's all defeated, so yes, what we said is we're not making a decision on it today, that just carried. However, now it's the staff report, and if there's no change to the staff report, then it will come back to the next council meeting for a decision. So the motion before council be amended as follows. All right. Okay, and these are the additions.
Through your worship, we'll ask the clerk to read it. And before you ask for a mover and a seconder, if there's anything further to be added.
The only thing I'll add as you read this, these are the amendments to the staff report, but the staff report will also still be reporting on what happens in a non-decision because that's already been approved by well, that's included in the original.
That is correct,
motion.
your worship.
Right. So go ahead.
Okay, that the motion before council be amended as follows. That staff be directed to provide a report to committee of the whole about next steps related to report BP 0126, including the feasibility of the following items to be addressed. Noise impacts, provision by the applicant of sufficient information demonstrating that quarry operations can be conducted without unacceptable impacts on nearby sensitive land uses. Blasting impacts, resolution by the applicant of concerns related to vibration safety and potential adverse effects on surrounding properties and the community, including but not limited to blasting shall be done by a licensed blaster using the Terra Rock model, no blasting on hauling on Saturdays, and no crushing or processing before 7 a.m. and operations limited to 7 a.m. to 7 p.m. by maximum. Air quality impacts, provision by the applicant of a sufficient assessment plan for the mitigation of dust, particulate matter, and emissions associated with quarry operations and related traffic. Traffic impacts, provision by the applicant of an analysis and mitigation strategy for increased heavy truck traffic, safety road, and impacts on the local and regional road network, including but not limited to driver protocols, mandatory tarping of trucks, compliance with stop signs, no roadside waiting on concession 2, adequate on-site washrooms, township approved dust suppression and regular road cleaning, installation of cameras at key locations with township access at the applicant's cost. The applicant would have no concerns if the township reduced the speed limit to 40 kilometers an hour on the municipally owned road from the quarry entrance to Highway 12, and all traffic studied must account for all existing and proposed quarry operations. Enforcement, granting the township the right to access and inspect at the applicant's expense for the purpose of reporting to the ministry. Agreement by the applicant to not restrict or comment on future development applications, and that staff be directed to speak with the applicant in preparation of the report regarding consideration of these items.
Could you put the last sentence up again? Sorry, I apologize. I was just following along.
Agreement by the applicant.
All right. Yeah. So staff's not only going to do the report, they're going to reach out to the applicant to see if they will agree to some or all of these terms. Deputy Mayor, comment.
Yeah, I just wanted to add one more piece to that, which is understanding the cost and liability by going to OLT as a non-decision or decision.
So at this point, Dave, we're taking the points that you mentioned to staff and we're taking them to the quarry directly to see what their feelings are on it prior to heading to an OLT or prior to council making a decision to see if they agree to any or all of. Oh, you're muted again, Dave. It must be automatic on your end. Nope, there you are.
Who exactly is staff?
That'll be our planning staff. Go ahead.
Through your worship, it
Yes.
would, this report would be prepared by planning staff, yes.
But not even, it's some internal and some external, I guess, on this particular file.
That is correct, your worship.
Yeah. We have hired planners.
Are they negotiating or are they just asking the applicant to say yes or no?
Through your worship,
Yes.
what I would envision occurring if this motion was successful is the general manager, as well as the township planner, as well as the township's consulting planning group would sit down with the proponents of the application to have the discussion with respect to all of these items that are included within the motion. And that outcome of those discussions would be included in the staff report. So for example, if the proponent was agreeable to installing cameras as an example, then that would be reported back to council that the proponent is in fact agreeable to installing cameras, just as an example.
And I can think of like the reducing the speed limit. I can't imagine why they would object to a reduction of the speed limit on our road for 400 feet. The trucks wouldn't get up to 40 prior to like certain, some of that I can see where they probably would agree. Some of the other ones may be problematic, but we'll wait and see what the response is. So this is on this amendment. So if everybody's clear, moved by Councillor Goff, second by the deputy mayor. Any other on the amendment to the staff report? Oh, and did we add what was to look into the cost as
Through
well?
you, your worship, just if I can ask the clerk to speak about the mover and a seconder and whether she's included that last piece regarding costs.
All right. Projected cost to go to an OLT because we're going to want to know that when we're making the final decision.
Could I ask the deputy mayor to repeat what he'd like included regarding costs in that motion?
For sure. Just talking about risk and cost. Basically looking at the liability of going to an OLT, whether it's a decision or a non-decision.
Yeah. So add that to the original staff report.
Commissioner in favor of that?
Yep. Yeah, they are. Yes. Okay. So on the motion on the floor, all in favor? You may want to support that one, Dave, because this is one where we're actually going to add to the staff report, but that's fine. All opposed? Okay, now the main motion as amended, correct? Right. So now we're voting on the whole thing as amended, the deferral. We already passed that.
You're correct, your worship. You've already passed that first component.
Right.
So this is just the main motion, which includes the staff report to include all of these things, plus the original intent, which is the outcome of a non-decision.
Right. So what we're voting on now, again, is the staff report again. This was the amendments that we added to it, plus the original request, which was to report back on the repercussions of a non-decision. So because the last one was an amendment to the planning to the planner's report. Now this is also, we also need to get the consequences of, which was the original motion.
So we've lost the opportunity to deny.
Yes, because it was voted on to defer. That was the original motion. So this is now on the staff report as amended. So the original staff report, which was a comment on the repercussions of a non-decision, plus the amendment that we just entered now, which is all the list of items that we just put on. So yes.
But it still can be declined at the next council when it comes back with the staff report.
Well, yeah, when the staff report comes back, that's when we'll be doing the final vote on the quarry. when we get the staff report. So moved by, yes,
Sorry, and then what happens if that vote's tied 3-3?
then it's a non-decision, but we'll have a legal opinion by then on what a non-decision would mean. Because that's part of the staff report. So,
Okay, so okay, so the 1,700 people that signed the petition still have a chance that we can deny this.
yes, because we haven't made a decision on the quarry yet. So moved by Councillor Goff, second by the deputy mayor on the original staff report, which was, again, the amendment we just added plus the original request of the repercussions of a non-decision. So everybody's clear on that? All in favor?
No,
Oh,
I don't know
okay.
which way to vote, but I don't think it matters. I don't think it matters. So just go ahead. Go ahead. Just call a vote.
All in favor? All opposed? And that is carried. Thank you. So we're actually done with the quarry. So now we are on consent agenda B, reports from the current meeting, and there was a few of them that we were going to, and I don't think anybody wanted any of them pulled, correct? And that's from today's committee of the whole, the items that we're going to pass directly. I think the 2 in-camera items as well as, but go ahead, Madam Clerk.
The recommendations as set out on consent agenda B, reports from the current meeting for the regular meeting of council held on January 26, 2026, be adopted as presented, including the following items. 11.1.1, CDO 126, unassumed township roads. Item 11.1.2, CDO 226, litigation update. Item 11.5.1, IDO 426, winter maintenance on Sunset Drive, and item 11.5.4, ID 0626, 2025 carryover capital projects.
Those are the items from the committee of the whole today. Does anybody want any of them pulled for a separate vote? I can't imagine not seeing that. So can I have a mover and a seconder to approve? Moved by Councillor Goff, second by the deputy mayor. Questions, comments? All in favor? That's from today's committee of the whole, Dave. All in favor? I'm just waiting for you to vote there, Councillor. All in favor of today's committee of the whole?
I guess so. I'm now really confused, but go ahead.
Okay, no, I'll take the time to clarify it because this is something we're going to want to amend our procedure bylaw, you know, after we've tried it for 6 months to see if we have any changes. This was the items on today's committee of the whole that we just finished a while ago that were to be ratified today. The amendment to the budget to carry on with the projects, the 2 in-camera issues, and there was another one to be ratified today. What?
Through your worship, it was the litigation matter, the item on unassumed roads,
Yes.
Sunset Drive, and the capital carryover.
And the capital carryover. Those then we discussed. All in favor? Yes. Okay, thank you. That is carried. Okay, and there was none of them contentious, so I didn't think any needed to be pulled, which would be 13 too. If any of them were pulled, there'd be a separate vote on them now, but there was no need. So consent agenda C, and this is the correspondence. I have 14.11 from the city of Peterborough and 14.12. Now, the suggested motions are here. Is anybody like a separate motion than what's presented in front of us? Not seeing any. So I'll recommendation that go ahead with the recommendation, Madam
We
Clerk.
have both items in one resolution, your worship,
Yes.
if you'd like to proceed with that.
Yes, go ahead and read the
That
motion
the
first.
recommendations as set out on consent agenda C, correspondence for the regular meeting of council held on January 26, 2026, be adopted as presented.
Okay, so is any questions or comments on?
Well,
Not seeing any. All in favor?
sorry, I do have a comment.
Oh, yes, go ahead, Councillor Snodge. Yep.
Yeah, I do sit on the OPP Police Services Board, and I do think it should be funded. So I'd like this to be changed to and support this. We're no farther ahead under this system than what we were, and I'm sorry, I should have changed. I thought we were going to have a discussion, so I know I should have said and support earlier.
Okay.
But I think there needs to be some changes for sure.
So why don't we'll vote on them both separately then, and we might as well just do them in order that. they
That's
come
fine,
then.
your worship.
So
We did
we'll have
not
two
have a mover
separate
and a
motions
seconder.
because there's only 2 items, so we'll just do 2 separate motions.
Okay.
So 14.11 we will do first.
I'm sorry, did Counselor Snatch indicate that he wanted to support?
Yes.
Yes.
I think the province should be funding this because we're now paying an expense, and I don't think we're any better off than what we were before.
So we would like an amendment to support. Yes, so Counselor Snatch will move the amendment to support, second by Counselor Goff. All in favor? That is carried. And now do we need to approve it as amended? And now mover, Counselor Goff, second by Counselor Snatch, that we approve the motion as amended. All in favor? And that will support. So it had to be 2 votes on that, Counselor, just in case you're wondering. Okay, so now we're on 14.12, which is the request from the Parks and Waterways Commission that we help out on the bill.
The Lagoon City Parks and Waterways Commission memo dated December 13th, 2025 regarding allocation of legal fees, file 25441-001 may be received as information.
Okay, so I'll get the motion on the floor, and this is to be received as information.
Right.
Yeah, a move by the questions for, well, let me get it on the floor. So moved by Counselor Goff, second by the Deputy Mayor. Comments, Counselor Snatch.
Yes, I do not believe this should be received as information until it can be checked factually and in a non-influential way. I'd be prepared to just not accept it, or I'd prepare for staff to come back with a retracted version of it for some of the reasons that the mayor said earlier, and I've got other reasons as well.
No, this is 14. This is directly from Parks and Waterways where they're requesting us to help out on the bill.
Oh, that, I'm sorry.
and
I'm
it would
still
be-
so confused on the quarry. I'm not getting my. Okay.
I know that. I can still see the steam coming out your ears.
Let's go.
All right, yeah, so this one is, what you would need on this one if you wanted to provide a grant, then I would have to have an amendment to provide a grant. Listen, we've all been through this court case, but I think what's not being explained clearly to the public, so I'm willing to speak on it. Everything this council did was on behalf of Parks and Waterways. And it's no different than our sewer and water systems. When we make decisions here on behalf of the sewer and water users, all the cost of that is borne by the sewer and water users. That's the budget where it goes. And that would not be any different even if there was a lawsuit. We're acting on behalf of. And in the case of this one, it was actually the Parks and Waterways that hired the lawyer that drafted the bylaw. It came to council. We followed the municipal act. We passed the bylaw on behalf of Parks and Waterways, and it went back to them for enforcement. And I think it's in the original Lagoon City agreement that all costs related to shore walls, whether it be construction or maintenance, is borne by the users. So this is part of those costs. Everything council and the township did was on behalf of Lagoon City Parks and Waterways. So this bill has already been allocated to that department. It did not require a decision of council because that is the procedures and policies that all costs are allocated to the proper departments when the bills come in. So if somebody wanted to change it and help them out, it would be in the form of a grant. So I've made that clear. The motion is on the table. I'd look for any amendments. Deputy Mayor.
Just so I can understand, so these shore walls, this bylaw did not affect anybody else in the township. It was very specific to Lagoon City.
It is a Lagoon City bylaw, well, a Lagoon City Parks and Waterways bylaw.
And where did
And there's always been one, actually. The original agreement, when the province passed the Lagoon City Act, there was a shore wall bylaw included in that. And it's been amended numerous times and replaced and rewritten, and it was the last bylaw that replaced the old one that was repealed and found to be, well, it was dismissed by the judge. So the old bylaw previous to it is now still on the record. At no time there would never be a bylaw. When a new bylaw is squashed, it automatically goes back to the old one, but the judge even stated that it would go back to the old existing bylaw.
Okay, and then maybe could you just clarify how we got to the point where council had to approve the bylaw and who actually motivated the bylaw change?
It was a request from the Lagoon City Parks and Waterways when they presented the bylaw to council and asked us to please approve the new bylaw. We had to go through the municipal act. So we had to advertise for X amount of weeks. I don't know offhand how many weeks that is. We have to hold a public meeting, which we did. And then the bylaw was passed and then actually handed back to Lagoon City Parks and Waterways, I believe, for enforcement. I think that was included in the original bylaw. It's no different again than the sewer and water bylaw. We have a bylaw on the record that you must join if a new water system comes, you must join within, or sewer system within 3 years. And anybody, if we had to litigate that didn't, that cost would be borne by that department. We also, if anybody, there's another bylaw for the sewer and water users that you pay triple payments if you do not have a meter. If somebody wants to challenge that and we went to court, those costs would be borne by that department after the litigation was over. These are bylaws that the township passes on behalf of these particular groups. And this one's a designated ratepayers, much like the sewer and water is. So that's where we're at. However, I don't think there's anything illegal if council wanted to send a grant, though it would be problematic with sewer and water because there's provincial legislation that comes into effect there. Okay, so the motion is on the floor to receive. Do I have any amendments? All in favor? Opposed, if any? That is carried. Thank you. So now we are on to items pulled for a separate vote. Well, we just did them all the separate votes. So correspondence for council direction is 15.1 and it's our auditor's planning report.
That the 2025 audit planning report be received as information and that the mayor and councillor Snutch sign the acknowledgement to be returned to Baker Tilly KDN LLP, confirming council's review and understanding of the audit plan for the 2025 fiscal year.
Okay, on the auditor's letter, can I have a mover and a seconder? Moved by Councillor Tuyu, second by Councillor Goff. Any questions or comments on the auditor's letter? Standard. All in favor? That is carried. Actually, I should have asked, is there anything council wants specifically audited? Would this be the time to ask, or would that come later?
Refer to the treasurer for that.
If there was something in particular, any account, or will there be discussion later when the audits come, if council or any department that they wanted special?
So every year, the auditors change what they look into and how they look into it so that we can hide anything. Like if we
Right.
knew exactly what they were looking for every year, it would be easier for staff to like move things around to if you know that was the intention, but of course it's not. I can't say what they will be looking at for sure. I do have a lot of reports to prepare, but if council wants something specific, then I can sure pass that information towards the auditors.
Okay. Don't think that would require a motion, would it? If council had specific concerns? Okay. Thank you. So that was passed. Postponed motions. Yes. Oh, did we vote on that? Oh, all in
Yes.
favor of the, I think we did. All in favor of the audit's report. That is carried. Thank you. Motions, postponed motions have none. Planning motions, none. Deputation motions. I have the one from the Jennings that the deputation by Georgie Jennings regarding allocation of court-ordered legal costs be received as information. That is the motion. Can I have a mover and a seconder? We'll get it on the floor. Moved by Councillor Goff, second by Councillor Tuyu. Questions or comments? Councillor Snutch.
Yes, thank you. I really appreciate Georgie doing the presentation today, but I can't accept this information until it's been fact checked. And I'm willing to receive a redacted version in the next meeting, but there are certain things in here that I just don't think it's fair to accept that information. We've got to accept information that's truth and accurate. I'd rather not get into the points right now because I myself don't know if they're true or accurate and don't want to defend them until we've had a chance to look at things. I certainly know things like what we said earlier as far as manufactured vote due to John O'Donnell. That's one fact, but there are other facts, and so I'd like to not receive it, and that would be my amendment.
I guess I'd look for, well, do we have a seconder for that amendment? I'd be looking for clarification by amending. I mean, when people do deputations, their opinions, So
right.
we're just receiving their opinions. I think I clarified some of those. I see no harm in receiving the deputation. It's one person's opinions that came to the council. It's quite a bit different when councillors start making comments that aren't factually correct, and those need to be challenged right away. But individuals of the public, when they're making their comments, it's their comments.
That's right. It's included in our procedure bylaw, your worship.
Yes. So I don't have a seconder for your amendment, Councillor. So then I'll put the original motion on the floor that we receive. All in favor? Opposed? One. That is carried. Thank you.
Who's the one?
Councillor
Who's the
Snutch, you were
one?
opposed, correct?
No, I was in favor.
Oh, you're
I
in
just
favor?
wanted to
Okay, it's
bring
just
it
your
up.
hand. Yeah, your hand, the screen delayed and your hand went up after. I was gonna make a comment. It looked kind of funny. The hand appeared and then just disappeared. Okay, so notice is a motion. We have none. Council motions for notice previously given, a none, but we do have an inquiry motion. So I move by Deputy Mayor Bell, second by Councillor Tuyu. Madam Clerk, if you would read the
That the
motion.
clerk be directed to review the township's retention policy with respect to meeting video recordings, and that the clerk report back to council with suggested updates, including options for extending the retention period for video recordings based on best practices.
I will go to the Deputy Mayor. It's your motion, comments?
Yep. I think my comment is pretty clear through the time I've been in office since 2022. There's been a lot of reasons why I believe that it's going to benefit us to have, an ability to go back and look at context. Sometimes motions and minutes, they don't give us the understanding and the debates that happened prior. I think that it'd be extremely valuable to have that retained for at least 5 years so that we have 1 year past an election year. So if we had a full turnover of council members, we'd have some video and some understanding of how they came to the decisions they made.
All right, so we're gonna look at the best practices. Any comments from the seconder to add to it? Go ahead, Councillor Tuyu.
No, I echo the same sentiments in terms of the timing, having it encompass the term of council that we're in, including the year from the previous term of council.
Okay, thank you. And I will make the request that an individual made. I know we have our current policies 1 year, some of them are 2 years. Do not take them down until council has a decision on this. I'm getting a nod from staff. I don't. Is that because the current policy
Through
is
you,
1
your
year?
worship, if I would.
We would need to add that to this motion, I think, because our current policy is 1 year.
Well, if we're waiving policy, if we're amending policy, that's a whole other issue, your worship. So what I would suggest is certainly staff look into that because doing that on the fly, your worship,
Right.
without the benefit of a report on the best practice on how to actually do that. I don't know why we have 2 years when our policy says 1 year. I'll have to look into that.
We will look, so,
But if I can, your worship, before we sort of make a decision on that, I need to understand better how we best do that.
all right.
Because
So we'll just pass the motion that is on the floor. Everybody's heard the comments. All in favor? We're going to look into best practices. That is carried. Thank you. Bills and bylaws. Madam
We have 3 bylaws that we're passing today, your worship. We can do them all in one or we can do them separately.
Does anybody wish the bylaw? It was to appoint our new legal staff. Didn't realize he was working for free for the last couple of weeks. Guess not. Yeah. The other one is for the levy and the payment of taxes. And the first one, I did them in the wrong order, is the Laidlaw Avenue road allowance. Those are the bylaws. Does anybody feel they need to be pulled? Not seeing any. So one motion then.
That bills 2026-02, 2026-03, and 2026-04 be read a first, second, and third time and finally passed as bylaws.
Moved by Councillor Goff, second by Councillor Tuyu. All in favor? That is carried. Thank you. And the confirmatory bylaw.
That bylaw 2026-06 being a bylaw to confirm the proceedings of the council meeting held on the 26th day of January, 2026 be considered read a first, second, and third time and finally passed.
Moved by Councillor Snutch, second by the Deputy Mayor. All in favor? That is carried. And now recommendation to adjourn.
That the council meeting of the Township of Ramara held on January 26, 2026 be adjourned at 12:40 p.m.
Moved by Councillor Goff, second by the Deputy Mayor. All in favor? That is carried. Thank you, everyone. Enjoy the beautiful cold weather.